While consumers may be concerned about their lack of privacy on the internet, thanks to the California Consumer Privacy Act, better known as the CCPA, businesses better be aware of how its enforcement can impact them. Hi, I'm Amy Grant of the ABL organization. Here are 5 key takeaways about the new law. First, the CCPA goes into effect on January 1st, 2020, which means the Attorney General, Xavier Becerra's office, can start enforcing it on July 1st, 6 months later. So what's the penalty for each violation? For intentional violations, $7,500 each. But even violations lacking intent will be subject to a $2,500 fine. Plus, individual consumers can sue for $100 to $750 each in the event a company is careless and gets hacked. According to Fortune, even if they're not actually damaged. But it's likely the largest cost will be for initial compliance, which is estimated to be upwards of $55 billion, according to a report issued by the Attorney General's office. Second, the new regulation requires businesses to confirm a California resident's request to identify or delete data within 10 days of receiving an inquiry about what personal information is being collected about them. Access that information, know if their personal information is disclosed and to whom, know if it's sold and have the right to opt out of the sale to third parties, and receive equal service and price whether or not they exercise their privacy rights. Third, businesses must act on that request within 45 days, regardless of time required to verify the request. Fourth, under the CCPA, your business will be subject to the law as long as, according to Forbes, your for-profit company does business in or has customers or potential customers in California, plus meets one of the following criteria. Your annual gross revenue is over $25 million. Your organization receives, shares, or sells personal information of more than 50,000 individuals, or your company earns 50% or more of its annual revenue from selling consumers' personal information. Fifth, since there isn't a federal data privacy law on the books or in sight, California's CCPA solution will be the toughest in the world, going further than the EU's GDPR. For anyone who saw Netflix's The Great Hack, and anyone who didn't, you really should, had CCPA already been in force and had David Carroll, the dark data professor from Parsons, who co-stars in the documentary, been in California, under CCPA, he could have demanded and received the data he sought from Cambridge Analytica. The fact is, now is the time to figure out how your company will respond to CCPA. For starters, Forbes recommends businesses take a hard look at their personal data governance capabilities and processes. One bright area for businesses impacted by the CCPA is a cure provision that gives companies an opportunity to remedy the effects of a breach before an affected consumer brings a lawsuit. According to Skadden Arps, the cure provision prevents consumers from bringing a class action for statutory damages. This is important because the CCPA requires courts to award successful plaintiffs between $100 and $7,500 per consumer per incident, which would add up quickly a class action suit. Clearly, avoiding the dystopian implications of the Facebook Cambridge Analytica scandal is a noble goal. I just hope in the state's effort to protect our privacy, we don't roll back all the life-changing free information and services that Google, Facebook, Amazon, and thousands of other companies have been willing to give us in exchange for a glimpse into the 5,000 data points that make each American uniquely susceptible to internet marketing. Well, at least that's my opinion. What's yours?